Please be seated. Okay, good, I guess it's morning still. We are here for oral argument. In our case, number CV19 0284. Counsel, each side has 20 minutes for argument. The appellant may reserve time for rebuttal. Just please keep track of that yourself with the clock on the podium. Our proceedings are being audio and video recorded. Please introduce yourself and your client when you stand at the podium. We have read the briefs, discussed the case at conference. Please keep that in mind when you make your arguments. And with that, counsel, you may proceed.
Thank you, Your Honors, and good morning. May it please the Court, my name is Stephen Hoffman. I represent Inscription Canyon Ranch Sanitary District. I have with me at counsel table Hans Klugston, who is co-counsel for the district. I would like to reserve 5 minutes for rebuttal. Your Honors, we're here today because the Superior Court misinterpreted and misapplied the moratorium statute, ARS 48-2033. The statute defines what is a moratorium and also provides what is not a moratorium. And in this case, we believe that the Superior Court improperly focused on the first portion, which is subsection G2A, about the definition of a moratorium. No, Your Honor, because the evidentiary hearing at the Superior Court level was expressly limited by the court to the sewer capacity issues, and pattern of practice was not brought up.
File a memorandum or brief or anything that made these arguments in the Superior Court?
No, Your Honor, because the issue of the pattern of practice did not come out until the court issued its ruling.
When you say the issue, let's separate the issue and the elements of the claim, which are always there, from the facts or the specific arguments. Your objective in that evidentiary hearing was to demonstrate what?
The evidentiary hearing was to demonstrate that the sewer plant did not have sufficient capacity for the forms to be approved.
To what? What were you seeking to accomplish?
To establish that there was insufficient capacity, and therefore that was one of the two bases that the forms were not signed by the district to substantiate the refusal to sign.
Okay, so it had nothing to do with the moratorium?
Well, Your Honor, the claims that were brought under the moratorium statute.
That was sort of the field on which you were playing.
It was, Your Honor.
And so to make it kind of finish the sentence, was there the capacity issue or was it a moratorium? Isn't that what it really came down to? That's what that hearing was about. Did your client have the ability to prove they had a factual basis for saying no, or was it something else, this moratorium?
Well, there are two factual bases for saying no, Your Honor. One had to do with the incomplete and inaccurate forms that included missing information and missing documentation. So there are really two reasons.
To settle that on your own aside, separate, correct? That was the agreement. We can take care of that.
There was an agreement to take care of that, Your Honor. Once that was resolved, the forms were signed. But that was still part of the lawsuit. That was still part of the moratorium.
That wasn't part
claim.
of the evidentiary hearing.
It was not part of the evidentiary hearing. The evidentiary hearing was strictly limited to capacity issues.
And if it wasn't the capacity, then it was the moratorium.
Well, no, Your Honor, because there were still the deficient forms, and so we believe there's no moratorium because of that reason as well.
You agreed to resolve that form issue. That was not part of the evidentiary issue.
That's correct.
And you went in the beginning of the hearing, didn't folks say we resolved the form issue?
I don't believe they said they resolved it, Your Honor. I think they said that we can resolve it. We will submit. The developer said it would submit forms.
So that's nothing to do with this hearing. At that point, the parties have taken it out of that hearing, didn't they?
Well,
court's not deciding it.
Not at that hearing, no, Your Honor. But until the forms have been provided and the district had responded to the new forms, that was still an open issue.
If you get sued under the moratorium statute, couldn't you make arguments under that statute about why it shouldn't be private?
Well, Your Honor, this was an OSC hearing, an evidentiary hearing regarding the developer's application for an order compelling the district to sign the approval forms. So in response, the district had raised both defenses. Number one, that it didn't believe it could sign because of the capacity issues, and second, because of the improper or deficient form issue.
Were you prevented from, in fact, I actually looked at, I think, your answer, and you do use the words pattern and practice. Were you prevented from saying, can you add one more point to that evidentiary agenda? Given the question was whether or not there's a moratorium or not, or these other permissible things.
Was it a delay or was it a stopping? And you said we had a factual basis for it, right?
Was there anything that
Yes.
prevented you from asking that that be tried or at issue?
Could have been asked to be added to it. Certainly, whether or not the trial court would have added it, I don't know, because my read of the record is the trial court expressly was limiting the evidentiary
So
hearing to the
could have been
capacity.
asked, and just to take away the passive voice, you could have asked.
My
right?
client counsel could have asked, yes, Your Honor.
Okay.
So let me come back though. Wasn't your argument though that we had a factual basis for stopping or delaying signing this permit?
We had two factual bases for
What were they?
not signing. One was that the forms were deficient and there were incomplete
The
and
form
missing
issue, I'm
items.
going to ask you to set that aside. You agreed at the beginning of that hearing, so that's not something the court dealt with. What was the second?
The second involved whether or not there was sufficient capacity, and the district actually requested to cancel or
And why
vacate
did
that
the
hearing.
sufficient capacity matter?
Because the one board member who testified that
Under the statute, why did it matter?
it would have mattered under the statute, Your Honor, if the district had taken steps to effectuate a moratorium, because there would be a public hearing.
And your point was we didn't take steps to effect a moratorium because there wasn't sufficient capacity. You never argued that we don't have a pattern, even if you find that we have delay or stop. You never argued the second part, which this isn't a pattern in practice. Or not you, but your client's attorney. I know it wasn't you.
Well, Your Honor, again, the evidentiary hearing is limited in scope, and it wasn't until the court
By what-
issued
by
its
what
under
order?
advisement ruling that the pattern of practice issue was raised by the
Can I
court.
break in here? You say it's limited in scope.
Yes, Your Honor.
How is it so limited? Is there an order saying
The,
this hearing is limited in scope?
the court expressly stated on the record that that hearing would be limited to the capacity issues only.
But then
and
the
that
court
the
went on
would-
to address moratorium issues, and no arguments were made about it. And I guess my concern, even though I'm fairly hostile to the waiver doctrine, is your client was coming into this hearing with some problems. And there were at least facial violations of the open meetings act. There was circumstantial evidence, at least, of the moratorium that was pretty strong. And it seems to me that if there's a construction of the statute that saves you, that's the kind of thing you got to argue when the court is saying there's all this evidence of a moratorium. And it seems hard to argue that we should take a look at that for the first time.
Well, Your Honor, I would suggest to the court that when you look at the record, the court at the end of that hearing directed my client or gave my client 30 days to evaluate the new evidence and decide whether or not it believed it could sign those forms at that time or not. And if it was not going to sign them, to state on the record at an open meeting why it was not going to do so. It was after all that occurred that the court issued a ruling finding a pattern in practice. Again, by that point, the issue was moot
Pattern
in
or
our opinion.
practice.
Pattern or practice, thank you, Your Honor. It's our belief that by that point in time, that issue was moot because the developer had already received what it had sought, which is the approved forms. I know they want to try and argue that, well, we wanted to amend the complaint, we had an attorney's fees application, they did amend, they withdrew the amendment, but that doesn't unmoot.
Let's say the court just said, I find a moratorium. And she didn't use the words pattern and practice. Isn't it a safe bet, given the elemental significance of pattern and practice as a definitional element, prima facie case of moratorium, that she would have tackled it? Didn't she need to tackle that?
I don't believe she did by that point, Your Honor, because once the capacity issue was resolved, it was after that that the forms were submitted and my client reviewed them and went ahead and signed
Right,
it.
so you're talking about the
Yes, Your Honor.
mootness argument.
Yes, Your Honor.
But I'm going back to the waiver argument. And to the extent there was a menu of items to be tried at any particular point, or discussed or argued, your client helped craft that menu and specifically excluded the term and the definition of pattern and practice, which is in the definition of moratorium.
I'm not sure I agree, Your Honor, because prior to the evidentiary hearing, the other issues have not been resolved, and at that point in time, the belief was that there would still be more litigation and other issues could be presented.
So you're saying once we found that this instance was bad, we'll just use an adjective that's easy, then we can move on and see whether or not there are others such that you might demonstrate what is a pattern or practice. But that's a secondary issue that you only tackle once you have found the singular first threshold instance of bad conduct. Is that your argument?
Not precisely, Your Honor. My argument is that at the time of litigation, that hearing was limited in scope. There were other issues in the case still pending that were to be resolved at a later date. So it's similar to what Your Honor has posited, but it's slightly nuanced from that. I would also note that the waiver argument is not something that should be rigidly applied, particularly in a case like this where the first ruling from the court came after the fact, and we have other valid basis why those forms were not signed. You know, it's a situation where...
Well, let me unpack that a little, because, and this is kind of goes to the mootness, but one of the issues in moratorium isn't just a denial, but it's a delay. And so there was a significant delay between the submission of the forms and the signing, correct? And intervening that was a lawsuit and an evidentiary hearing and a court order to either sign it or say why not in an open meeting.
Well, Judge Gass, I don't necessarily agree with that because the initial forms that created delay were the deficient forms that were submitted by the developer.
Your client hadn't even read those forms, though, had they?
Well, I'm sorry, Your Honor?
There's evidence in the record that shows your client hadn't even looked at the forms.
I don't believe that's established in the record, Your Honor, because there are meeting minutes.
Didn't the board chair say we hadn't even looked at them? We decided we weren't going to sign anymore, and we didn't look at them?
I'm not sure which particular forms he was referring to or which submission at that point, Your Honor, because he was also asked some hypothetical questions about what would you do in the future if any forms were submitted to you.
Let's assume that's there. The other thing is, your client was the one who had the numbers that your client said were wrong, and your client didn't give them to Talking Rock.
Well, I believe Talking Rock
That's the form issue.
Well, that's part of the form issue, Your Honor, because there were also two additional forms that were supposed to be attached to the approval forms that Talking Rock had not even created at the time they'd submitted the applications. So those were deficiencies were 100% on Talking Rock, and those weren't corrected until a day or two before the evidentiary hearing.
And at no point was your client even willing to say these are the form problems we have. It was just executive session out. The reasons we talked about were denying and never told them why, did they?
The minutes are silent on that, Your Honor, yes.
I'm sorry.
But Your Honors, you know, it's not a situation where we've been denying applications for this developer for an extended period of time. In fact, they put into the record reference to another 115 applications which were approved by my client prior to these 45. So, you know, it kind of begs the question that if you're going to submit an improper application or deficient application and repeatedly submit a deficient application, does that mean you've created a moratorium? For an example, if my client approves 99 out of 100 for one developer, rejects one because they believe it's deficient, rejects it a second time because they believe it's deficient, but they've approved the other 99, and their belief as to deficiency later turns out to be erroneous, is that a moratorium under the statute? And I don't think that's a fair interpretation of the statute.
So far removed from the facts of this case that I'm not sure that answers the problem. What do you think the Superior Court should have done here?
Well, I think once the issue became moot and the court acknowledged the issues were moot because the developer had obtained its approvals, the court should have dismissed the case at that time. The court had the ability, I think, under 122030 to award fees under that statute. It did not. Instead, it awarded fees under the moratorium statute, and for reasons set forth in the brief, we believe that the court improperly found a moratorium had been enacted, and therefore an award of fees under that statute was improper.
Well, again, though, given the nature of the proceedings, the court went ahead and found that a moratorium existed. What did you do to argue against that?
Well, Your Honor, the issue was not presented that way at that evidentiary hearing, so there was no direct argument against it other than to point out that Mr. Barrera is one of 3 board members. He certainly could have been overruled. His personal belief about what he might have done in the future is not enough to create a pattern of practice.
I think we're off the question I was asking. The court was quite vocal about its sense that there was a moratorium.
It was.
That seems like a golden opportunity to make the arguments that you want us to consider for the first time here.
Well, Your Honor, I think those were presented at the beginning of that hearing when the issue of the forms was discussed. And I understand Your Honor's position that, yeah, they agreed to go resolve that outside the hearing, but it was put on the record at the hearing that there were still other deficiencies in the application process.
No, pattern and practice, I think is what.
Yeah.
Right,
If I do a word search.
No, I understand,
on
but
that document, a transcript, I say pattern. How many times does that come up?
a number of times, Your Honor.
The transcript of the evidentiary hearing, I will find the word pattern.
Well, I don't know if it's in the evidentiary hearing. I believe it was one of the subsequent hearings.
Which transcript?
It may have been, Your Honor, where the judge talked about Mr. Barrera's testimony and his belief that that testimony, if that's not a pattern in practice, I don't know what is. The
Okay,
trial
where
court
did
said
your
that.
client raise the issue and say, this isn't, I mean, when the judge says that, that's your invitation, I believe, to say, wait, Your Honor, that isn't a pattern in practice. Did your client do it?
I believe that was done at the beginning of the hearing, Your Honor, because subsection B of the subsection 2 says that a pattern of practice or moratorium does not include a denial of permit and applications because they're deficient. So I believe that issue was raised at the beginning. The parties agreed they would handle that aspect separately, and therefore...
Where did your client agree the pattern in practice would be handled separately?
Yeah, and what does that mean, separate?
That the form issue would be resolved outside of that
That's
hearing.
Not the form issue, the element of the moratorium, the definitional element. You raised
I don't believe
pattern
it was
practice.
discussed.
In your answer, you have a whole paragraph dedicated to pattern practice, right?
Yes, Your Honor.
Okay, but it disappeared.
Yes, Your Honor. Again, the evidentiary is limited in scope, and it wasn't until the court raised that it was brought up, because the evidentiary was not supposed to be addressing the pattern and practice issue.
Yeah, I'm not a fan of waiver either, but I think it's important to allow the Superior Court to comment on something you're asking us to overrule the Superior Court for.
Well, Your Honor, I think under the Tovery Land and Cattle case, the facts aren't in dispute, so I think this court can substitute its judgment for the Superior Court under this fact pattern.
Why was there an evidentiary hearing if the facts were in dispute? It sounds like there are a whole ton of facts in dispute here, and some of them were kind of swept aside for... I'm not sure why they were swept aside. There are some troubling facts here, and nothing seems undisputed.
Well, the deficient forms is undisputed. The fact that the court relied apparently on Mr. Barrera's testimony to establish the pattern and practice is undisputed, and that's the issue on appeal.
Well, but the fact that your client violated the open meetings law repeatedly and severely and said it wasn't signing anymore is also undisputed, isn't it?
Well, Your Honor, that issue actually never went to a hearing at the lower court either. So that was one of the other. That never went to a hearing or resolution at the trial court level either.
Is it a disputed fact? Because if we're going to look at the undisputed record and make our own de novo determination, that's a big one for me.
I agreed that when the board came out of executive session, it went straight to vote.
But your
And there's
client
no
also
open
said they
discussion.
wouldn't sign anything. That's not
One
just
board-
the board coming out under oath. That's what your client testified to.
One board member testified to that.
And
Yes,
he
Your
said
Honor.
that he talked to a second board member, correct?
I
And they had
believe so.
agreed. We'll set aside the open meeting issue on that one as well, and there are only 3. And he used the word we. It's not just I, but we. Didn't he?
Again, Your Honors, it's hypothetical as to what they would do in the future. And
But no,
with Your Honor's
it wasn't
permission,
hypothetical. He said, we won't go. We were not going to sign anymore. That wasn't hypothetical.
well, I believe he was asked if you're presented with any of these in the future, would you sign them? And he said no. So again, it's what would you do in the future? And Your Honors, if you indulge into
Sure.
reserve my last minute.
We'll make sure you have a full minute.
All right, thank you.
Thank you. Counsel.
Good morning. May it please the court, Sean Hood of Fenimore Craig on behalf of Plaintiff Appellee Talking Rock Land. I'm going to start not where I intended to, but where you left off, because I think it goes right to the heart of the matter. There may be times when waivers shouldn't be applied. This is certainly an instance where it should. And my colleague, Mr. Hoffman, made the point for me. Judge Napper never reached the open meeting law violations for the very purpose that he didn't have to, because he found that this was a moratorium. Having determined that this was a moratorium, a pattern and practice, he said it in open court as you just identified, he didn't have to reach the question of our claims of an open meeting law violation. If this argument had any legs, I don't think it does, but if it had been raised and it had legs and Judge Napper decided this wasn't a moratorium, we would have continued the litigation and we would have had an open meeting laws
Let me
claim.
ask you a question. The moratorium, we're talking about a statute, right?
We are.
All right, words of the legislature. And that is what dictates whether or not it's a good claim or a bad claim. All right? They write the instruction guide, the booklet. So how do we find waiver when you're talking about the DNA, the very inherent instruction, we're going to play Monopoly, right? And we open up, you look at the instruction, you're supposed to get this. How are we supposed to look past that and say that was waived if, let's say, it's a completely erroneous interpretation of the statute? It was just never waived. Isn't that different? Qualitatively, aren't there gradations of waiver and different types of waiver?
There might be, Your Honor. In this circumstance, we had, and I want to go back to the reason the hearing was limited to one issue. The district raised two defenses. One was the form issue, and as Judge Goss recognized, that was set aside and resolved outside of court. The capacity issue was the other one. They raised capacity. They did not raise anything about pattern and practice. The reason the evidentiary hearing was limited to is there a capacity problem is because that was the lone defense left standing. So this is the point. Had they raised pattern and practice, do these four denials of Talking Rock under the cloak of executive session constitute a pattern? Does it constitute a practice? That wasn't disputed. The district didn't raise that argument.
And I'm on board with that. I understand you have arguments that were not raised. I'm talking about something a little deeper. Okay? Let's say that the order said a moratorium requires that the chairman have worn a red coat. And that's that's in the decision, and that's interpreting the statute, okay? And that comes to us, and your colleague never raised that and said, well, you look at the statute, that's not what it requires. Do we just sort of look past it and say, yeah, the statute does, the red coat thing is, yeah, that's in there.
I could see, Your Honor, where it would be a viable rule of law to say where you have an absurd ruling that is completely divorced from any factual determinations, that this court has the right to take a look at that. I don't have any problem with that concept. That is far removed from our scenario.
Okay, so we have this sort of continuum of absurdity. Is that what?
Perhaps. I'm not aware of that case law that would support the idea that the red jacket ruling can be revisited, but I will grant you that would certainly be a justifiable rule of law if it were to be this court's rule.
But aren't there cases where we'd have said, look, it's a statutory issue, and we don't want to reach the wrong result and give people the wrong instruction just because a party didn't raise it below, so we will reach it.
There are cases to that effect.
And so why isn't this that case?
Because we provided evidence that it was a pattern in practice. They didn't dispute it. So the evidentiary hearing was limited to the issue of capacity. This is a perfect example of why the waiver doctrine exists. If they wanted to raise this argument, they should have done it then, and our presentation at that evidentiary hearing might have been different. Judge Napper's evaluation might have been different. The way he wrote his order might have been different. He was precluded from evaluating that issue. It sure appeared to him it was a pattern in practice, and the district didn't deny that fact. So that's why this case is not susceptible to that kind of approach.
So is it more, it's not as much a waiver, but they conceded
I think it's both.
De facto, whether expressly or impliedly conceded the issue?
Absolutely, and I would note, you're absolutely correct to observe that when Judge Napper says, I find these facts and I find that this is a pattern in practice, that is at the bare minimum the latest time they should have said, oh, I guess we should be arguing this. They didn't do it then. There was post-trial briefing, multiple rounds, it was never raised. There was a motion to reconsider the ruling about a moratorium. Pattern in practice was never raised. I mean, at a certain point, if we do have a continuum, and I'll acknowledge perhaps there would be circumstances, we're way over here. It's waived, it's conceded. It would be unfair to Talking Rock, it would be unfair to Judge Napper to revisit that issue for the first time here. Excerpt of Record 60, motion for reconsideration. Argument's not made. The first time that argument shows up is in the appeal briefs.
Can I ask you, what is this statute? Why are we concerned about a moratorium? If you can provide some background generally. I understand we have a monopolist that sort of controls the water tap, literally, but if you can explain it.
Well, this isn't water service, this is sewer service. So
Right.
You do have a monopolist, and if they won't hook you up, you've either got to put in a septic system, which buyers in these kinds of communities hate, or you can't build. And in fact, this district has its own regulation that says you can't put in septic systems. We're going to dominate this market exclusively.
But if your colleague just denied once, you agree with me that that's apparently not a violation of the statute.
I disagree with that. And it's always been Arizona law that the starting point for a sewer district, which is a public body that has a monopoly over their service area, has to provide service unless, okay? And in 2009, they entered a moratorium in violation, again, of the open meeting laws, long history of this, litigated that to conclusion. The legislature's response was, we're going to make this really clear what you have to do to deny service.
Right,
The
I saw
opening,
you argue that, but I didn't find that.
the opening,
Any record site or?
the opening, and that may not have ended up in the record, Your Honor, and so that's for context and background, and so I apologize for that. This is the point. The opening words of the statute aren't no moratorium. The opening words are, a sanitary district shall provide continuous service. And it goes on. The other thing it has to do is not enter a moratorium unless, and there are a lot of statutory requirements, and most of them boil down to, it's the district's job to keep its eye on capacity. It's the district's job to plan ahead for additional capacity when needed. And if they're really up against it, they have to do detailed fact finding. They have to publish that detailed fact finding. They have to submit public notice of a hearing, and they have to conduct an open hearing before they can do that.
So what's the meaning, or why is that included, those three words, pattern or practice?
You're not going to want to acknowledge that it's surplusage. I think that it frankly might be surplusage, given that they have a duty to provide service unless. But pattern and practice, you know, if they get a form and there's a problem with the form and they come out of executive session and say, hey, we're ready to sign this, but your forms are all wrong, that's not a moratorium. I acknowledge that. We would have fixed these forms immediately had they come out of executive session and did that. We had a representative there at all 4 board meetings. Does the legislature intend that the district can one-off deny sewer applications? I don't think that's the purpose of the statute.
Let me ask you this. Did they engage in a pattern or did they engage in a practice?
Both.
Okay. How did they engage in a pattern?
They engage in a pattern. We have, in the course of a decade, we have 5 refusals for service. Okay, the first one was 2009. That gave us the moratorium statute. Then in 2018, we had 4 board meetings where the Sterling Ranch approvals were up for consideration.
Case.
Correct. 4 different board meetings, 4 different times those approvals were agendized items for approval, and each time they were rejected without comment.
Well, so that's good. They weren't just on the agenda. You heard the word no.
Correct.
Because that's different, right? You would agree with me, right? Like, oh, we just, it's on the agenda, we'll push that. You know, we have another argument today, let's push that, and we push it 4 times. Is that a pattern or practice of, you know, whatever, denying? And we deny it, let's say, the last time we hear it, the case.
Some of those board meetings, they were out and out denied. Some of those board meetings, they came out of executive session and said, we're taking it off the agenda. The result to my client is the same. They're refusing to provide service in
Oh,
violation
no,
of the statute.
and I understand
Yeah.
that, but that's, we're asked to interpret a statute.
Yeah,
And having an agenda item that is continued for whatever reason, lack of time or ill motives, that's something that a trial court would definitely be interested in. But
had it been presented to the trial court as part of an argument on
right,
pattern
right.
and practice.
Well, no, that's
Yeah.
a good point, a fair point. But you would agree with me though that there's a difference between saying denied and then requiring you to come back, put it on the next item, denied, versus just bump it. That's
It's-
well, one's certainly more of a pattern or practice.
The statute is deny or delay, and so could we
Okay.
come up with a hypothetical where there was sufficient good cause for pushing it to the next meeting because
Oh.
they're out of time, or we could probably come up with those facts. What we have here is
Okay.
a very clear pattern of this district refusing these approvals for reasons discussed in executive session. Mr. Lynch, the district's counsel, he was very open with Judge Knapper. The reason we can't sign these, in our view, is capacity issues. So they were kicking the can for capacity issues. The moratorium statute says you've got to deal with those in a particular fashion. This is a pattern.
So either way, it's a pattern of practice because you had said denied each time, but it could have been denied or delayed, and you still win.
And
I
isn't-
believe so,
And isn't
Your
part of the
Honor.
problem why you can't answer the question because whatever decision was made, it was made in executive session,
True.
and so it was never stated on the record.
True. There were at least one or two occasions where they came out and said, we're not signing the forms for reasons we discussed back there. And then there were times they came out and took it off the agenda, but there was never a discussion about justifications or rationales.
So is your argument that it was a delay or a stoppage?
Both.
And how was it, how?
Okay. Requests were made. They were denied on multiple occasions. They were delayed or denied on the other occasions. So either way, it fits the statute.
How
There were.
about then you get to the end where they signed it? So is it a stoppage at that point?
At that point, it was not, but we had to litigate to get that result. I mean, at that point, the moratorium was effectively ended, I suppose, but that was not until we had to do at an evidentiary hearing what the district's legal obligation is to do pursuant to the moratorium statute pre-litigation.
Would it be fair to say it may have been mooted as to the stoppage issue, but not as to the delay issue then?
I don't think it was mooted in terms of Judge Knapper no longer had to write an order saying, writ of mandamus, you got to go do this. He didn't have to write that anymore. It certainly didn't moot the case as to our existing from day one attorney's fee claim. Let me check my notes real quick. We covered most, I think, of what I intended to. Oh, one point I would make on this issue about Chairman Barrera was only one of the board members. It didn't speak for all of them. Judge Goss, you made a good observation about the language used, and it's we. I would also note, Bob Lynch, attorney representative for the district, was very clear with Judge Knapper. We're not signing forms because of capacity. So that was the litigation position. And if they had wanted to dispute that fact or say, hey, maybe we would have granted other forms, they had an obligation to bring those witnesses forward. They chose to bring forward the chairman. His testimony was clear. His testimony was uncontroverted. And so Judge Knapper absolutely was well within his discretion to make those findings of fact based upon that testimony. With that, Your Honors, unless you have any questions for me, I think you understand my position.
Thank you for your argument, Mr. Hood.
Thank you, Your Honors.
Mr. Hoffman. I'm going to give you
Thank
three
you.
more seconds than that. Just so
Thank you.
know.
Thank you, Your Honors. I would say this in closing. My client raised two defenses at the trial court level. One was the capacity issue, and one was the deficient form issue. The deficient form issue wasn't resolved until after the evidentiary hearing. You have a situation where if you prevail on one defense and you don't prevail on the other defense, but one of the defenses is valid. And it's a valid defense under statute to a moratorium. That is, you denied it because the applications were deficient. That should be a sufficient basis to continue to deny the forms until they're, factually right. So we believe that there was no moratorium because even though one of the defenses proved unfounded, the other one was substantiated at the trial court level. The developer acknowledged and admitted that their forms were deficient at the trial court level, and those deficiencies, weren't corrected until just before that evidentiary hearing. And at that point in time, my client reviewed them and went ahead and approved the applications.
Thank you, Mr. Hoffman. Thank you both for your argument today. We will take it under advisement, and that will be adjourned.